What are the legal definitions for assault charges? Imagine someone raising their hand to threaten you, making you fear they might hit you. That feeling of fear is what legal systems call assault. Assault charges are about actions that make someone believe they are about to be harmed. The key point is that assault does not need actual physical contact. If a person acts in a way that makes another person reasonably think harm is about to happen, that can be enough for an assault charge. Legal definitions focus on the victim's perception and the intent of the person accused. The law says the act must be done knowingly and without lawful reason. If someone points a gun at another person and threatens to shoot, that is assault because it creates a reasonable fear of harm. The law also says the fear must be reasonable, meaning an average person in the same situation would believe harm was imminent. Assault is different from battery, which involves actual physical contact. For example, if someone pushes another person, that is battery. But if someone just raises a fist and threatens to punch, that is assault. The threat alone can be enough to charge someone with assault. There are different types of assault charges. Simple assault involves threats or attempts to cause harm without weapons or serious injury. It might be a shove or a verbal threat that causes someone to fear harm. Aggravated assault is more serious and involves weapons, causing severe injuries, or targeting protected people like police officers. Using a deadly weapon like a knife or gun during an assault makes the charge more severe. Domestic assault occurs when someone harms a family member or partner. Sexual assault involves unwanted sexual contact, which can range from inappropriate touching to rape. Verbal assault, in some places, means threatening someone in a way that makes them reasonably fear harm, even if no physical contact occurs. The law says the person accused must act intentionally and without lawful reason to cause the victim to reasonably fear harm. The victim's fear does not have to be actual, but it must be reasonable from an outside perspective. If a person acts in a way that a typical person would see as threatening, that can be enough for an assault charge. Understanding these definitions is important for legal defense. If there was no physical contact, the case might be assault rather than battery. If the accused did not intend to threaten or cause fear, that can be a defense. Challenging whether the victim's fear was reasonable or if the threat was credible can also help. Different types of assault carry different penalties. Simple assault might mean a small fine or short jail time. Aggravated assault can lead to longer prison sentences. Because these charges can have serious consequences, having a lawyer to review the case and find the best defense is always a good idea. In short, assault charges involve actions that make someone reasonably believe they are about to be harmed, even if no physical contact happens. The specific type depends on factors like intent, weapons, injury, and relationship. Knowing these details helps in understanding how the law treats different assault cases and how to defend against them.